we've had a number of people who are very interested in following up and learning more about this. So we are recording this event so that we can have this for our other HR members and board members who would like to hear the presentation. So with that note, you have been duly informed that we are recording.
Okay, so welcome everybody to the November meeting of the Darke County Chamber of Commerce HR Council. Today we have a guest speaker, Ryan Gleason. Ryan is manager of the Great Lakes region for the U.S. Chamber of Commerce, and he's going to speak to us on the new OSHA vaccine mandate, which I know is near and dear to many of us, and I hope that, I look forward to learning some new information. So Ryan, we'll go ahead and let you take it away.
Ryan, would it be helpful for everybody to kind of introduce themselves quickly so that you kind of know who we are here?
Yeah, that would be great.
Okay. I'll go first since I'm already talking. I'm Peggy Emerson. I'm the president of the chamber. Allison?
I'm Allison Brigitzer. I am the chairman of the HR Council.
Shelley? You're not muted. I can hear you.
Okay, sorry. I'm like, I can't find my buttons. I'm Shelley Peters. I'm with Comprehensive Health Network here in Greenville, Ohio. I'm the HR clerk.
Jeff?
I'm Jeff Francis with Phelan Insurance Agency.
And Nikki?
I'm Nikki Stevens from Council on Rural Services, and we have a head start in Greenville and several other counties. I'm the HR compliance coordinator.
And Terry?
Hi, good morning. I'm Terry Becker. I'm a chamber board member, and I'm the executive director of the Tri-County Board of Recovery and Mental Health Services.
And Becca?
Hi, I'm Rebecca Liette. I'm vice president of marketing at Pole Transportation.
And let's see, Sana?
Yes.
Okay. Oh, we're going to just introduce ourselves. We're introducing ourselves to the speaker. So go ahead and introduce yourself. She's just getting situated here. Just your name. And
my name. Oh, I'm so sorry. I had to type in the Zoom meeting all the way because I couldn't find the initial email. And so my first name is Sana. I'm HR manager for Klockner Pentaplast. It is manufacturing facility here in Greenville. So hello.
All right, and then oh my gosh, I'm drawing a blank on first name. Philip. Go ahead. Last person.
It's Rose Flippo.
Rose, thank you, Flippo. Yeah, sorry. That's what happened when I had my list in front of me. She may be multitasking. So, all right, Ryan, just go ahead. Well, you got an idea what we got? Manufacturing, healthcare, all sorts of folks on here. So, yeah.
Well, good, Peggy. Thanks for having me on this morning. Typically at this time in Washington, it's pretty lull. They're just trying to get sunsets passed, continue resolutions. But now we had the ETS finally come out last Thursday after months and months of waiting, particularly for large employers. I'm sure you all saw that the bipartisan infrastructure package passed in Washington on Friday. Not here to talk about that, but that was a huge win for the chamber, and I'm glad that Peggy and a number of our chambers across our region were supportive. So today we're going to go over the OSHA ETS mandate, as I mentioned, came out last Thursday. Instead of boring you with talking about two for 30 minutes, it's a lot to cover. So I put together a slideshow last night that hopefully can help guide us through here. So let's see. And if at any point, Peggy, you can't hear me, feel free to shout out. So again, this morning we're going to go over the OSHA COVID-19 vaccine mandate for large private employers. Just want to do a few quick points here, just an overview. So last week, as I mentioned, OSHA released its ETS standard for large employers. Large employers, as we'll discuss, are over 100 employees or more. For non-compliance is a fine of roughly $14,000. However, that's subject to other means as well. If a company is flagrant in its implementation, it could be charged up to $140,000. Additionally, in Washington right now, that coincides with infrastructure is the president's Build Back Better plan or budget reconciliation. In that plan, any sort of violation, just as a standard violation, would be $70,000. So that's something to keep an eye on. Additionally, CMS, the Center for Medicare and Medicaid Services, also released its standards. So they changed the deadline as the OSHA rule. So now January 4th, I'm sure you all have heard, that's the big date. As we'll discuss later, that really isn't the big date. December 5th is, and we'll touch on what that is about. No updates for the federal contractors, but that was extended to January 4th as well. It's worth noting that employers covered by CMS rules or federal contractors guidelines are not affected by OSHA. So CMS and Medicare and Medicaid and healthcare workers and federal contractors are separate from OSHA. Another thing I would like to touch on here as well is that lawsuits could delay implementation. And so the way that this kind of works is there is an expedited process for emergency temporary standards. 10 days after standard is released, lawsuits have to be funneled. Well, in the Fifth Circuit Court, they actually put a stay on the standard. We'll see what happens with regard to the stay, meaning it's kind of in pause. Dates could be changed, so as I will continue to note at the end of the program, to continue to check your FAQs just because the rules and the regulations are changing. But with regard to lawsuits, there are 9 circuit courts throughout the United States, along with DC circuit courts. And what's going to happen ultimately is all these lawsuits are going to funnel through one of the circuit courts and kind of, if you view it as a lottery pick. And so that's really going to determine where this standard goes. So next we'll talk about who is affected by this. As I had mentioned, it's employers with 100 employees or more are covered meaning that they are covered by the standard. And who does this include? It's pretty broad ranging. It includes full-time, part-time, temporary employees, paid interns, anyone on payroll counts. It counts seasonal employees if seasonal employees are on the payroll. Obviously, with the holiday season coming up, seasonal employees are not few and far between, so they will count as well. Additionally, all of these are aggregated. So if you have a business, let's say business A, business B, business C that have 30 employees, and 40 employees, that counts. You reach 100 employees, you are affected by this. You are covered by the standard, and this goes into effect December 5th, as I had mentioned. Now, who is not included in this? For the most part, independent contractors, 1099s are not included. However, OSHA has come out and they have said that it's kind of at their discretion. So if in the event that they check in on you or your company, that they will have the discretion as to the effect of the independent contractor as whether or not they should be included. Additionally, if franchisees are separate from this, so for example, if there's a franchisee A and franchisee B that have 50 and 50 employees, that would not count as well. Lastly, as I had mentioned as well, for the federal contractors and subcontractors, their safety guidance is separate from OSHA's guidance, and so that's worth noting. And then additionally, we're healthcare service providers or healthcare support service. They're also to a separate standard, section 10 or 1910.50, which I included in the red there. And then Peggy, also worth noting, I'm happy to share this presentation with those on the call after, just because I know it's a lot, and especially if their questions are not answered at the end. So then who's exempt?
Thank you, and I also, Ryan, thank you. And if you could flip back to that for just a second, I seem to recall from last week, Friday's call, that you also, they're going to be coming down hard, like you can't fudge this. You can't say, oh, this company is A and they have 40 people and this company is B, when they're all in the same organization actually, correct?
Correct. If it's all under the same organization where it's the same employer, then it counts, except for the separate instance of franchisees. So if you have mom and pop shop that's in downtown of Darke County somewhere, and there's the same employer somewhere else in part of Darke County that total up to 100 employees, they are covered.
Okay, right. Yes, and we did send out the summary as well, and I really want to thank the U.S. Chamber for that on Friday, the summary of the ruling. That was very helpful, I think, for folks to see that 3 or 4 page summary. So
You're telling me it was helping from it was good for myself as well. It was difficult to digest this 900 or 490 page standard. So now, who's exempt from OSHA? Well, first and foremost, OSHA preempts any inconsistent state laws or local laws that may come forward, including some Ohio laws. There was one that was filed the other day that I'll discuss. So federal law is supreme. So if a state law comes out and says, mandates are not necessary for vaccines, or testing isn't necessary, or masking isn't necessary in the workplace, that doesn't matter. A federal law takes precedent. However, there is one exception where the federal law does not take precedent, and that is if states or local municipalities enforce more protective and, quite frankly, more rigorous protocols, such in New York City, for example, as I'll discuss later in the program. If an employee of yours tests positive for COVID, they are not subject to paid leave. However, in the case of New York City, they are trying to make that to be the case. And so as a result of that, technically, according to OSHA's standard being more protective, that would be covered. So who does it not apply to as well? So anyone who doesn't report to the workplace where individuals such as coworkers or customers are present. So we're talking about people that perhaps have their own satellite office, and as it says below, are remote working from home, as a number of us are. But that means that they are not in contact with anyone in your office or anyone in any customers that they may come in contact with. In the event that they do, they either have to be vaccinated or they have to prove a negative test by the time that they come into contact with any of your colleagues or customers. And then lastly, those who work outdoors. A number of people work outdoors, truckers work outdoors, but they're in a trucking setting. Those wouldn't count. Although Uber is a 1099, but there are some private ride shares that pick up food. They're outdoors and perhaps drop it at someone's front door. The fact of the matter that they're in a vehicle means that they are not exempt. So people that are strictly outdoors and would be exempt from this. However, it's worth noting, though, that those employees that you may have that work from home, that might be a truck driver of yours, individuals that might have their own satellite office, they still count towards your employee total. However, they are exempt from actually complying with the standard. So next year, we're probably going to discuss the most important part of it. This will be kind of the longer slide. There's two-part action here, and then we'll kind of recap what is required. So the premise of the OSHA standard, first and foremost, to make sure that all of your colleagues and employees are vaccinated. So quite frankly, you should create a separate policy statement saying that so-and-so business requires or mandates vaccinations, so you are required to be vaccinated. Point blank and simple. That's how I would first start off your policy. However, there's an exception to this policy, as I kind of discussed. So for those larger employers that want to do a separate policy that require all employers to be vaccinated, or also be masked and provide weekly test results as it relates to the coronavirus. Other policy standards that must be required, and we'll review them in a couple of slides here, must include anti-retaliation, anti-discrimination guidance set out in rule. They also must mention criminal penalties set out by OSHA Act for providing false information or documentation. Employers, and we'll discuss this a little bit further, must provide accommodations for religious and medical issues. And the policy does not actually need to mention accommodation rules. So in your policy statement, you can write what the rules and requirements are, but you do not need to explicitly write out that those that potentially could be exempt would be accommodated. However, there are a couple of other issues as it relates to it as well. But covered employers must distribute copies of the CDC guidance on COVID-19 vaccines. This is much different from the Families First Act. When the coronavirus happened, you would put up kind of COVID guidelines and rules, perhaps in your place of work, let's say in your kitchen. Not the case here. Each employee needs to have a CDC guidance available to them, available here through the link that I had provided at the bottom. Covered employers must determine the vaccination status of all employees through specified documents or attestation, which I'll discuss in a little bit here. Now, what sort of vaccines are accepted? Well, first, it's the 3 vaccines that we know here in the United States. The first is the 2 shots of Pfizer, 2 shots of Moderna, and 1 shot of the Johnson & Johnson. What's not accepted is prior recovery or some sort of natural immunity. Additionally, other sort of vaccines that are accepted are vaccines that are approved by the WHO. Let's say, for example, you have a colleague or an employee that had been traveling overseas and decided to get a vaccine in a different country where that's accepted. That's fair game. Additionally, other vaccines that are going through trial tests that are proven to be effective, such as AstraZeneca, those are acceptable as well, so long as that the employees are not taking the placebo effect. There are issues here as well as it relates to accommodations. But before we go into that, the 4 main things that I know Peggy wanted me to hit on of what need to be provided. So first and foremost, the following information must be provided to employees from an employer in the language of the employee's understanding and understood literacy. So first, information regarding the ETS and the workplace procedures to implement the ETS, whether that be that all employees must be vaccinated and or tested weekly with masking. Second, a CDC document titled, and I quote, key things to know about COVID vaccines. Third, information, as I mentioned, about retaliation and discrimination. Employees need to know what the cause and effects of that will be. And then fourth, information about criminal laws for knowingly providing false statements or documentation. So again, here, not to be confused with the January 4th date. This needs to be completed by December 5th. So we've talked about a lot about accommodations. So first and foremost, the ETS notes that the American
Ryan, I'm sorry to interrupt you. Back to that previous slide. Will the chamber have those type of items, or will OSHA come out with, okay, this is the documents that are needed for each company to give to their employees, or is this something that each employer will have to put together on their own and make sure they hand out?
Good question. So for the second, third, and fourth, the chamber will have something available for it, and so will OSHA and the CDC. However, with regard to the first one, as it relates to the latter half of it, that is your policy of how you're going to institute the program. I'm not a lawyer, so you'll either have to work with legal counsel on that or work with us at the U.S. Chamber as we begin to see companies develop their policy language.
Okay, thank you. I'm sorry for interrupting.
Absolutely, no worries. So again, here with regard to accommodations, so under federal law, essentially OSHA had said that the American Disabilities Act and the Civil Rights Act of 1964 entitled with reasonable accommodation from their employer. And so what does this mean? This means that with regard to a disability, if an employee cannot wear or be vaccinated or wear a face mask because of a disability, they have to be entitled to a reasonable accommodation. And so what does that mean? It potentially means that the employee, works from home, potentially working with, in good faith effort, other sort of social distancing standards, different masking requirements, that employee perhaps having their own enclosed office space, potentially offering paid leave. Those are the sort of things that could be accommodated. And I'll touch on a good resource for accommodations. There really is no federal standard for accommodations. So in addition to if the vaccine or the testing of COVID-19 or wearing a face mask conflicts with a worker's religious belief, that worker also may be entitled to an accommodation. So the standard does not contain rules for when accommodations are due as well. So employers have to consult with the EEOC guidance. However, with regard to accommodations, there are still a couple of questions that the standard really didn't set and put forth. For example, we know a large issue for particularly a number of women is if they are pregnant and what that sort of accommodation looks like. We're still not sure, and so that's why I will repeat with regard to the frequently asked questions that OSHA puts out, changing by the day. We're working with them to make sure that pregnant women, to see if they can be accommodated as it relates to getting the vaccination and/or testing. So what to do with holdouts, individuals that simply for medical or religious reason, the standards for accommodations I had mentioned are weekly testing, masking, working from home. Other accommodations could be provided as well, such as giving them a satellite office, potentially working at different hours. Those are different accommodations that could happen too. But then, there's also individuals out there that are quite simply saying, I don't want to get a vaccination for no particular medical or religious reason, or I don't want to get tested. I just don't trust it for no particular medical or religious reason. And so ways to handle that is, if you're a generous employer, obviously offering paid leave, but you could also offer unpaid leave or furlough. The part where, again, I'm not a lawyer here and I wouldn't necessarily suggest this, but obviously the final route could be termination. But obviously, as we all know, that really could affect potentially some sort of civil action or lawsuit as well. So with regard to alternative testing and masking rules, so again, this needs to be covered by December 5th. So covered employers given a choice to adopt separate written policy requiring testing every 7 days and masking in the workplace if an employer does not want to go mandatory vaccination route. So whether testing or masking rules adopted voluntarily or due to accommodation, a few limitations apply. Unvaccinated employees are covered by the weekly testing requirement only if they report to the workplace at least once every 7 days. So let's say you have an employee, again, that's working from home, has been working from home for now 20 or 21 some odd months, needs to stop in the office once in a while and perhaps wants to see colleagues, pick up something from his or her desk, print something. In that event, even though that they're not in the workplace every day, they still need to be tested and prove a negative test before coming in. Secondly, once an employee has a positive test, there's no more testing that can be required from that employee for 90 days from diagnosis. So obviously, with a positive test, unfortunately, a number of us have received, you kind of go to the guidance of the CDC, where you shelter in place and make sure that you take care of yourself first and foremost. Finally, with regard to alternative testing, you cannot test from home. Tests need to be done in a laboratory or in a pharmacy. So there's also a chance, very limited chance, that tests are not available or there's lab delays. While this seems incredibly rare and very unlikely, there is the chance, just because of the wrath of the American workers that are going out there, that are going to be getting tested. So there is a chance that that could be the case. In that event, OSHA, as long as they will come in to make sure that you're putting forth the correct efforts and abiding by your guidelines, and as long as you're making a good faith effort, you and your employees should be fine. So next, we're going to go into testing here. So it's unclear who pays for the weekly COVID test. The standard explicitly says employees may, but they're not required to pay for testing. This is where it gets a little confusing. For example, you may have an employer who is tight on employees, and employees may have some sort of fiscal restraint in the sense of paying for testing. That employer may end up being willing to pay for their employees' testing weekly or once in a while. If that is the case, an employer is not allowed to ask for the money back for that sort of testing. Therefore, it lays on the burden of an employer. So ETS also warns that employer payment for testing may be required by other laws. That also relates to state and local, because it is separate and is written out specifically in the standard. So specific information with regard to this, you'll have to get from counsel or from lawyers as well, as it relates to laws either in the state of Ohio or in Darke County. So the FLSA, the Fair Labor Standards Act, which was changed pretty dramatically as it related to COVID for the Families First Act, passed last spring. Issues costs on the test itself are murky. So under kickback rules, if an expense is primarily for the benefit or the convenience of the employer, there are limitations and deductions of wages. So again, an employer cannot ask for the money back or withhold deductions on an employee's wages. Additionally, FLSA guidance fairly clearly states that the time spent in testing is compensable. So in the event that an employee needs to go get tested weekly, that is a part of their pay.
Ryan, this is Peggy. I don't want to jump ahead.
Sure.
Is it possible for a large employer, say like a BASF or a Whirlpool, can they have someone come in and actually just do the testing on site for their employees if necessary?
Good question. So certainly if it's someone that is certified to do the testing, they absolutely would be allowed to do that. We've seen employers already begun to do that. However, granted, that was before the ETS standing, but as long as it is a certified medical individual, a pharmacist, then that would be acceptable. Okay. However, an employer would not be allowed to do it. And again, that's not where we allow, testing from home. Right.
Well, yeah, but that could facilitate both the who's paying for it and the compensable time. So, thanks.
Exactly. Mm-hmm. So another key aspect of the standard is the OSHA paid leave rules, which really have kind of ruffled some feathers. So it requires that covered employer provide a reasonable amount of time to employees for their vaccination doses. Now, reasonable amount of time is really subjective, depends on what that means. So it separately rules that employees must provide up to 4 hours of paid time for this purpose. Well, does it mean paid 4 hours total? So for example, if you get the Johnson & Johnson shot, as we all know, that's one shot. You get 4 hours just for that one shot, or if you get the Pfizer or the Moderna shot, you get 4 hours per each shot, or is it 8 hours total? That remains unclear. So either way, the rules suggest even though if an employee needs more than 4 hours to be permitted, if reasonable, even if unpaid. So it is worth noting, though, however, with regard to the paid leave, so whether or not This would be deducted from an employee's paid leave that they already have. So if an employee still has 4 hours of paid leave and they decide to use it all on this, that is still considered. However, if employees have exhausted all of their paid leave, granted it's the end of the year, and so that's understandable how that could be the case. Unfortunately, paid leave would have to be provided by the employer. Now, some of the biggest questions and what frets employers the most are really the reporting rules. And so as it relates to reporting, so covered employers, again, employers with 100 employees or more must report work-related COVID deaths to OSHA within 8 hours. All work-related COVID inpatient hospitalizations must be reported within 24 hours. But here is, for a number of you HR folks on the call, this is a big one. So within 1 business day, must make records available to any employee who requests the information on the aggregate number of fully vaccinated employees at a workplace and the total number of employees. It's key to point out here, as I'm sure you all know, personal information such as names, when vaccinations occurred, do not need to be distributed. Other things is that what else do you need? So what sort of proof of documentation do you need? Someone's COVID reporting card. For those of you that have been vaccinated, this has kind of been the most standard procedure for it. Proof of immunity from a pharmacy or a medical provider. Medical records would be accepted as well. In the event that there's fraudulent proof that's provided by an employee, employers are not at the cause of fault for that, so long as they do not go along with it as well. So you need to also continue to capture negative tests. So essentially what you are going to need to do as HR professionals and employers is really create new files for employees for how they can be shared. I mean, as it also relates to the new paid leave, as it relates to payroll, you're going to have to figure out a different category as it relates to these new OSHA rules when it comes to your payroll. So the deadlines here, again, as I mentioned, everyone was talking about January 4th. That's really not the case. When the ruling came out, they had 30 days to essentially implement their policies, so that would be December 5th. It is worth noting that December 5th is on a Sunday this year. It's unclear whether or not employers actually have to have this information by that Sunday, contrary to other sort of federal guidelines where it has to take place on a business day. But if it is in the event on a Sunday, employers need to start moving now, and they cannot start scrambling on a Friday. And so what is required by December 5th of this year? To determine the vaccination status of all employees and obtain proof, provide leave for those seeking vaccination or experiencing side effects, require notification for any employee or any positive tests and exclude the employee. Unvaccinated employees must be masked in a workplace or a vehicle. Mandatory tolerance of face masks for employees and customers and visitors. Finalize all rollout of mandatory policies. Remember those 4 points that I talked about, and distribute CDC information on vaccines. Begin reporting of workplace-related COVID-19 hospitalizations and deaths, and make information regarding the number of vaccinated employees available to the employee upon request. So really the ball begins rolling here on December 5th. But as it relates to January 4th, so this is when the commencement of testing and masking rules for the unvaccinated begins. Now, a question a number of people have had is, well, let's say I got my Johnson & Johnson shot on January 4th. And as we all know, for vaccines, they technically take 2 weeks to kick in, or 3 weeks, I cannot recall, it's been so long. Or if I got the Moderna shot and I got my second shot on the 4th, or the Pfizer shot on the 4th, According to OSHA, they are covered. They would not need to be masks or vaccinated. Also, it's worth noting that if an employee does come back with a negative test and they are unvaccinated, they are still required to wear masks in the workplace as well. So the same deadline applies for the CMS rule and the federal contractors rule that I'm sure maybe a few of you may have questions on. Attached here is the White House spreadsheet. And so some resources. I know Peggy said that she distributed our kind of quick fact sheet. While I am not as astute or as brilliant as our vice presidents for labor and employment policy, they had a very thorough briefing last Friday, kind of going over this employee temporary standard that I included there. You can download the ETS from the Federal Register website. And then there's a summary sheet available at the OSHA website as well. Again, I'll repeat here, keep an eye on the FAQ because it's rapidly changing. And then I'll touch on a couple of other things. So what we're seeing in Ohio, and we're starting to see in a number of states, State Rep Tracy Richardson introduced House Bill 447 the other day, which prevents Ohio schools, private colleges, employers from mandating vaccines. That's her prerogative, but however, the federal standard still takes precedent unless it's struck down in a court of law. And it's just worth noting that the text of this legislation would include mandates and vaccinations against any disease. So I thank you for your time. I know that, all of you, or for most of you as HR folks, you are some of the most exhausted people of the last 21 and a half months. And this is really the last thing that, any of us, let alone you all, want to see going into the holiday season, trying to be compliant with all of this. As I mentioned with regard to accommodations, there is really no federal standard for accommodations. But let me share my screen again. So there is a website called askjan.org, and that's Job Accommodation Network. So that's askjan.org. They have a plethora of different accommodations that employees may be seeking, whether it relates to the OSHA standard, the coronavirus, or any other sort of accommodations that employees may need. And with that, Peggy, I'll kick it back to you for any questions that you all may have and hopefully be able to answer. You might be muted.
I am. I'll let Allison, or if anybody else wants to jump in and ask Ryan questions. I think that we're a pretty small group here. We'll just let everybody have at you, Ryan.
Friday, I'm ready for it.
Yeah.
I'll go first if nobody else is ready to speak. Is that okay?
Yeah.
Okay. So my question is, this is in the court process being attempted to be blocked. How long does that process usually take? Because I'm not going to take the steps towards December 5th if it might be resolved before. How long does that usually take once it hits the court?
So they have, I have to look at they have 10 days for suits to really kind of funnel. It's an expedited process. They have 10 days to do it. So that'd be 7, 8,
The end of the weekend, right? I mean,
so it would be the end of the weekend or Monday, but essentially it would kind of lead up to the beginning of December of whether or not it could be struck down. However, what the issue is that if the appellate court, or if it goes through the circuit court, so quite frankly, there's 10 different circuit courts across the country. As I had mentioned, there is kind of it's really the luck of the draw as to what circuit court gets all of these lawsuits through it, and depending on which court it is will really affect it. But more than likely, this could go to the Supreme Court if that is the case. So my point being said, this could be decided by a court without any sort of appeals by beginning of December. And in the event of that, and somehow this rule stays is put forth, you could have an appeals on it where it's still continuing to move forward. And so that's why we urge employers to at least take the basic standards, those 4-point standards, and apply them to your work, because you do not want to fall behind the ball on this one. But it's really tough to tell just to see how the legal process works and plays out. And I really can't put any sort of predictions of how this will play out legally.
Sure, no, I totally understand. We're a trucking company and we definitely have over 100 employees, and the logistics of this is going to be an absolute nightmare because none of our drivers are domiciled in Versailles. So it's going to be really crazy. So my second question to you, you're talking about reporting, OSHA or to OSHA any COVID deaths within an X amount of time. So it's been a while, but when COVID first started, we did have 3 drivers pass away. I mean, we didn't know for weeks what the official cause of death was. So what do we do in those situations to be compliant?
Right, and so really good question. And so what's assumed that because employers under this standard are taking efforts to abide by this standard, there's really no other way to know whether or not, and first and foremost, employers are not liable in the event that one of their employees die or a customer dies as it relates to COVID, as far as I know. And that's something that we've been pushing for, is liability reform and protection for employers. But because of this standard, the only way to exactly know where someone potentially would have gotten something is in the workplace, because there are standards up. So let's say, for example, one of your truckers, and I'm sorry to hear that they passed away, went to a grocery store. There's really no way to know about him or her as a customer whether or not that they contracted it in the grocery store, just because the grocery store isn't putting on testing or any sort of process for its customers. So in the event, it's just to be assumed, because your truckers or employers are in the workplace adhering to these standards, it would be assumed that it happens in the workplace.
Who else has questions for Ryan?
I know
Okay.
you said that this is being recorded. Is this
Yes.
slideshow also being sent out?
Yes, Ryan, you
Okay.
said you would share that. Yeah, we'll get that sent out to everybody.
Perfect.
Absolutely.
Perfect.
There's
Thank
a
you
lot
so
of,
much.
there's a lot of links and a lot of information in there for sure.
Yes. Yeah, for sure. Thank you.
So Ryan, and I know that neither one of us can really give this advice, but as the kid who, maybe always did the least that I could possibly do in school and still get a good grade. So if in like Becca's situation, would you say maybe to definitely begin to draft that policy that you have to do that first document, the policy, and get that regardless, and get maybe those other things sort of downloaded and prepped, even, and keep watching what's going on?
Well, that certainly, those are really the easiest steps. What I would begin doing today is, quite frankly, because of the standard that is out there, we are just trying to make sure that businesses have resources, best resources possible to adhere to it. Is the most difficult thing, if it does come out by December 5th, is quite frankly finding your employees' vaccination status. That is going to be the most important and really rigorous thing to do. I mean, it's easy to print off. You could take one whole Saturday and create some policy, let's say on the 4th, and print off 100 pieces of CDC and provide them, etc. Finding employees' vaccination status is going to be the most critical part, because that's how you can best address and assess what sort of policy you want to move forward. Let's say, for example, you have 108 employees and 107 of them are vaccinated and one doesn't want to. Well, then at that point in time, it could be reasonable for you to create a mandatory vaccination process, because quite frankly, you wouldn't have to deal with all of the testing and other sort of protocol moving forward. I mean, I know that's a very low likelihood, but I'm just saying that as an example.
Thank you.
Well, yeah, one thing I've seen, now we're under the 100 employee threshold, but I think our payroll provider has sent something out. I've not really looked at it as far as tracking vaccination status. I don't know if anyone else has looked into that with their payroll provider, or if you have someone, I don't know if it's some type of software that you're using, if they, like I said, if they go forward with this.
And also, don't forget that through SACA, the Southern Ohio Chamber Alliance, we do have access to an HR company that will consult and help you with different things. So if you're interested in their contact information, I can get that to you too, if that's something that might be helpful. She was actually a speaker a few months ago here on our HR council. Go ahead, Ryan.
Jeff, how many employees do you have?
We are at anywhere between around 40.
Okay. So let's say, for example, Jeff had 98 employees. If he were to hit the 100 employee threshold at any point after December 5th, he's locked in. Now, let's say one of your companies have 101 employees right now on December 5th, and they drop down to 98 employees on January 3rd. You're still grandfathered in. So that is worth noting as well. Additionally, this is a 60-day program, or 6-month program rather, but OSHA reserves the right to make this potentially permanent. God willing, that's the case. So it's worth noting that this program from December 5th will go another 6 months up until May 5th. So really it's up to you, to your discretion of how well you can handle this and see where the world is at come then. But again, you are grandfathered in if you have 100 employees on December 5th or after December 5th.
Right, I think that was mentioned, even like retail, I'm just going to throw Kohl's out there, where they hire a lot of folks holiday. Even if that number drops back down after holidays or whatever, you still are going to be in this. Once you're in the program, it's like the mafia. Once you're in, you're in forever.
Yeah, it's really unfortunate when, I mean, there's really no way around it, but it's just unfortunate that the timing of it, just because of the number of seasonal employees for especially big box stores as well.
Which probably all hit the 100 employees anyway. But it's those smaller places that might bring on some extra hands for
Sure.
holidays that really need to watch that. And I was on the presentation last Friday, and it's one of the links that Ryan sent, and I think that was also excellent, and would recommend listening to or watching. It's 3 guys in suits talking heads, so you could probably just listen to it, but watching and listening to that as well. Very good. Anyone
And then,
else?
lastly, I just know that, Matt Appenzeller at, Southern Ohio Chamber Alliance, I know he's doing his best working with us at the Chamber. And, we're going to continually be providing updates as things change. So definitely we'll keep you in the loop, Peggy, so you can relay to your members. Any other specific questions?
I think we're good. Thank you, Ryan, so much. Allison, I didn't know if you had anything else you wanted to say. She's the chair. I'm just the chamber person.
I know. No, thank you very much. That was extremely informative.
Yeah,
My
and I
pleasure.
so appreciate your being able to jump on with us this quickly. Give us so much good information. So thank you, Ryan.
All right, well,
right.
thank you, everyone. Have a good weekend. Take
You
care.
too. All right. Thank
Thanks,
you, guys.
Ryan.
I'm going to stop recording at this point. Let me find my little